request that exhibit number 3, number 2, TAF 2, exhibit number TAF 2, since the prosecution maintains that it really makes no difference, will be regarded as irrelevant. I shall not use the contents of this letter, both of them. Does Dr. Servatius attach relevancy to the letter he submitted to court, or can this letter also be disregarded?
Ich beziehe mich auf den Brief, den Adolf Eichmann geschrieben hat. Das ist wohl Exhibit P3.
Das ist זה נכון, שזה היה. אני הבנתי קודם
I understood that you refer to the letter written by him. This seems to be my mistake. I refer to the letter written by Adolf Eichmann himself, marked as exhibit number 3. You ask to disregard, to remove from the proceedings the letter written by the accused. Is that correct? Or your letter to the Minister of Justice, or both letters?
Ich beantrage nur zu streichen den Brief, den ich selbst geschrieben habe. Während den Brief, den Eichmann geschrieben hat, den halte ich für erheblich, und der Streichung würde ich widersprechen.
I refer to exhibit number 2. I wish to declare as irrelevant only the letter written by me to the Minister of Justice, and not the letter written by Eichmann, which is relevant in my opinion. Why is the accused's letter relevant in Dr. Servatius' opinion?
Weil aus dieser Erklärung, wenn sie gültig
please go on.
נא להמשיך.
If you have anything further to say, Dr. Servatius, please continue. On the subject of these two letters which was raised here.
אם יש לך עוד דבר מה לומר לעניין שני המכתבים האלה אשר התעורר כאן, נא להמשיך.
Ich kann nur kurz noch erwähnen, dass der Brief Eichmanns jedenfalls erheblich ist für die Rechtsentscheidung. Und es kommt nicht darauf an, ob der Staatsanwalt ihn nun für erheblich hält.
I will say shortly that Adolf Eichmann's letter is relevant regarding the decision in the case itself, and it makes no difference if the Attorney General claims the letter to be irrelevant. May I reply, Your Honors? Your Honors, I mentioned and submitted Dr. Servatius' letter because I do not want different measures in court. I cannot, on the one hand, attach when he mentions the official messengers of the State of Israel and to rely on the very same letter for any other purpose. Either the letter is not to be accepted by the court, or the letter cannot be relied upon in one matter and disregarded in another matter. I shall now speak of another point. We shall come to a decision regarding the admissibility of this letter.
Darf ich eine Bemerkung noch zu den Ausführungen des Herrn Generalstaatsanwalts machen?
Will you please tell him that the ordinary procedure is that he who objects voices his objection, and then his colleague replies, and only by special permission of the court another objection may be voiced. But there must be an end to the discussion. This time I shall allow to Dr. Servatius to make his remark.
Ich will auch nur sehr kurz etwas sagen. In diesem Schriftstück sind zwei verschiedene Dinge enthalten. Einmal die Zusage desjenigen, der gezwungen wird, und dann das Versprechen desjenigen, der die Gewalt hat. Das Versprechen des Gewalthabers das ist unanfechtbar. Das muss erfüllt werden. Und deswegen ist das Dokument hier erheblich, bezüglich des zweiten Briefes.
In this document, there are two different things. The one, the consent of the man under duress. On the other hand, the promise by the man in authority. And this promise must be kept. I understand that you contend that the part speaking of a promise is allowed and permissible, and the other part is inadmissible.
Jawohl.
Yes, that is correct.
Dr. Servatius,
I regret, but I understood that your last argument was referred to your letter of the 22nd of December and not to the accused's declaration. Regarding this letter of the 22nd of December, you say that in part it is admissible and in part inadmissible. Did I understand correctly? Or did you refer to exhibit number 3, the accused's declaration?
Ich glaube, ich habe mich nicht gut ausgedrückt. Der von mir geschriebene Brief, P3, Exhibit P3,
das ist
das P2. P2
ja.
Ist in allen Teilen richtig und wird nicht angefochten. Ich habe nur als Entgegnung auf die Ausführungen des Herrn Anklägers gesagt, die Forderung, die ich gestellt habe, beruhte auf der wirksamen und vollgültigen Zusage, die in dem Schreiben gemacht worden ist, was Eichmann geschrieben hat, von dem ich aber sage, es ist ihm unter Zwang diktiert worden.
Ja, doch.
I believe that I did not express myself clearly enough. The letter written by me
על הפרוטוקול.
The letter written by me, exhibit number 2, is correct. And no one questions this letter, but I replied to the Attorney General and referred to the promise included in Eichmann's declaration, which I maintain was dictated to him. This is a decision marked as number 1. We admit exhibit number 1 as an exhibit in this case without deciding upon its evidential value. I wish to explain to Dr. Servatius that in future, if he wishes to object to the filing of an exhibit, he has to do so before the exhibit is marked by court. Otherwise, his objection may come too late.
Jawohl, ich habe es verstanden.
I understood. Before I begin analyzing the documents, I wish to touch upon a question raised by the defense, and this is the difficulty of preparing the defense because of the fact that the case is being conducted in Israel, and he cannot, as he says, bring his witnesses to Israel. Some of them fear for their own security, and others, there is no one to finance their travel and their stay in Israel. In a previous conversation with the defense, I have informed him that I shall recommend to the court, although the decision lies with the court, that affidavits will be presented as evidence, and if the defense has people who are ready to come and be witnesses, I shall not block the way, I shall not put any obstacles, and although I shall not have the privilege of cross-examining those witnesses, I shall agree to admit such affidavits, of course, after discussing the question of the relevancy of such affidavits. I am also ready. You say in general that you are ready to accept affidavits from the witnesses for the defense now abroad and to forego your right to cross-examine. No, my consent is not so general. But if the defense can convince this court that a witness has what to say which is relevant to the case but cannot come and appear before this court because of crimes committed by the witness himself, or because the defense has not the financial means of bringing the witness, I shall be ready to discuss each case, and when I see that it is only fair that the affidavit should be brought before the court, I shall recommend that the affidavit be accepted.
But the problem will arise as to how the court will be able to judge the credibility of any particular evidence, of any witness, if there is no cross-examination. Generally, in the cases when witnesses appear, the waiving of cross-examination by the opposing side is generally regarded as evidence of no argument with regard to the evidence of the particular witness. If this conclusion is not reached, how can the court judge between credible and evidence and evidence which is not credible? If the court desires my reply, I should be glad to give it. If and when a concrete case arises, we shall deal with it as the court pleases. The relevance at this stage is to be seen in the fact that the Attorney General wishes to reply to the argument that there cannot be a fair trial because of the impossibility of bringing certain witnesses for the defense from abroad. What I'm saying is that in regard to evidence given by way of affidavit, this is not quite so good because the court cannot easily decide between true and untrue evidence. May it please your honors,
after we shall conclude the calling of witnesses to weigh what is credible and what is not credible, the court will be able to choose what is important and to decide upon what is credible and acceptable as evidence. In any case, we speak of a law with special regulations regarding the law of evidence, and this is a difficulty which arises before the court. The court will have to decide. Therefore, I am not scared of this argument, but I am ready to take another step forward. And if the defense maintains that of those people who wish to come, but I cannot force them to make declarations or affidavits. Had the case been conducted in Germany, the court could have forced those people to appear before court and to give their evidence, but I have no means of forcing them to do so under the circumstances. Therefore, I declare that I shall be ready in a suitable case after being convinced on the face of it at least that for this purpose we shall give the legal assistance existing in Israel and in agreement with the Federal Republic in order that people who have something to say in this case will appear before a justice in Germany, where they will be examined by representatives of both sides with a cross-examination, and their words will be subjected to the question of credibility, and then I shall request the court to be more correct. I shall have to ask the defense to file this material as evidence in this case. I believe that this is the maximum I could do to promise the defense that all relevant evidence, if he has such material, will be brought before this court. Yet, I did not up to now receive from the defense the name of a witness who wishes to come but cannot do so because of fear for his own security. Now, by permission of the court, I wish to touch upon legal points and touching upon the kidnapping and the bringing of a person from one sovereign state to another. I maintain that when a man is charged legally for committing an offense and is held in custody legally when brought before the court to sit in judgment upon him, the court will not look into the circumstances which brought about the appearance of the accused before the court. In other words, the circumstances of the arrest and the bringing of the accused to this court is not relevant when the question of the competence of the court is discussed. And since they are irrelevant, they should not be discussed, and there should be no evidence brought on this subject before this court. This decision and is also the rule in other states where the common law is the rule. Since the decision taken in volume 109 of the English reports, page 166. And the facts were against a woman by the name of Susanna Scott, an indictment was filed for perjury. An order for her arrest was issued. And by permission of the court, I shall continue to read the facts and quote them from the reports themselves.
A police officer to whom the warrant was specially directed apprehended Scott at Brussels. She applied to the English ambassador there for assistance, but he refused to interfere, and Ruthven conveyed her to Ostend and thence to England, and on the 9th of April she was brought before Lord Tenderton and by him committed to the King's Bench prison. A bill was found against the prisoner for a misdemeanor. There is no doubt that she is now rightfully in custody for want of bail. Where a party is liable to be detained on a criminal charge, the court will not inquire into the manner in which the capture was effected. And in
the following page, Lord Tenderton, Chief Justice, continues and says,
this: whether if a person charged with a crime is found in this country, it is the duty of the court to take care that such a party shall be amenable to justice, or whether we are to consider the circumstances under which he was brought here. I thought, and still continue to think, that we cannot inquire into them. If the act complained of were done against the law of a foreign country, that country might have vindicated its own law. If it gave her a right of action, she may sue upon it.
The same question was discussed in England, 120 years later. And I quote again from the judgment declared by Lord Goddard in the case of Rex against Officer Commanding
Ex parte Elliot,
1949, All England Law Reports, Volume 1, page 373. And this concerns a British deserter arrested by British officers in Antwerpen 2 years after his desertion and brought to England. He was granted an order nisi that he was under illegal arrest because of the fact that he was brought from Belgium against his will and by duress. I quote from the judgment on page 376.
2 points have been taken. It is said that his arrest was illegal because 1. The British authorities had no authority to arrest him in Belgium, and he was arrested contrary to Belgian law. 2. His arrest was not in compliance with the provisions of Section 154 of the Army Act. The point with regard to arrest in Belgium is entirely false. If a person is arrested abroad, and he is brought before a court in this country charged with an offense which that court has jurisdiction to hear, it is no answer for him to say, he being then in lawful custody in this country, I was arrested contrary to the laws of State A or State B where I was actually arrested. He is in custody before the court which has jurisdiction to try him. What is it suggested that the court can do? The court cannot dismiss the charge at once without its being heard. He is charged with an offense against English law, the law applicable to the case. If he has been arrested in a foreign country and detained improperly from the time that he was first arrested until the time he lands in this country, he may have a remedy against the persons who arrested and detain him. But that does not entitle him to be discharged, though it may influence the court if they think there was something irregular or improper in the arrest. Once he is before the court, it can hold him to bail until his trial and conviction.
That is, that the question of kidnapping may influence, perhaps, on the question of release on bail. After quoting the case of ex parte Scott, the court analyzes a Scottish case and says on page 377,
clear and unambiguous statement of the law administered in Scotland. It shows that the law of both countries is exactly the same on this point, and that we have no power to go into the question once a prisoner is in lawful custody in this country of the circumstances in which he may have been brought here. The circumstances in which the applicant may have been arrested in Belgium are no concern of this court.
Sinclair.
The High Court of Palestine during the mandate followed a British and an American case, and in appeal case 14 of 1942, Afune against the Attorney General, 1942, 9 Palestine Law Reports, page 63, the same decision, and it was decided in this case a man who escaped to Syria was suspected of murder, was arrested in Damascus by a British sergeant, brought to the country for judgment. He claimed that his arrest was unlawful, therefore he should be released. And the High Court decided, I quote from page 66,
"The authority cited is an American state case, which of course is not binding on this court. Nevertheless, we adopt the language used, which is as follows."
I quote the American citation.
"Where a fugitive is brought back by kidnapping or by other irregular means, and not under an extradition treaty, he cannot, although an extradition treaty exists between the two countries, set up an answer to the indictment the unlawful manner in which he was brought within the jurisdiction of the court. It belongs exclusively to the government from whose territory he was wrongfully taken to complain of the violation of its rights."
And the court
accepting that view of the
continues,
law, we think there is no substance in the extradition point. בארצות הברית של
in
אמריקה
the United States of America,
קיימות ערובות קונסטיטוציונליות מיוחדות
exist
לשמירת זכויותיו של הפרט.
constitutional securities for the guarding of a person's rights.
עקב היותה מדינה פדרלית,
Since this is a federal state,
היא רגישה ביותר
the state is very
לבעיית
sensitive
הסמכויות של
to the
השלטון
question
המרכזי
of the authority of the central government
במדינות המהוות את
and
הברית.
the rule of the states composing
שמדינות
this
הברית ביניהן לבין
federation.
עצמן
The
ויחסי
states
ארצות
themselves
הברית עם מדינות חוץ.
and the relations between the United States and foreign countries. Moreover,
בתי המשפט האמריקאים
the
פסקו
American courts decided
כי החוק
and
הבינלאומי
ruled
הפומבי
that
הוא
public
חלק
international
מן
law
החוק הפנימי של ארצות הברית,
is part of the internal law of the United States
והוא חל על יחסי ארצות הברית
And
ומדינות חוץ ועל יחסי
applies
המדינות ביניהן לבין עצמן.
in relations between states in the country, in the United States, and relations between the states and other countries.
בית המשפט יראה את ההלכה הזאת
The court will find this decision in American Jurisprudence, Volume 30,
בעמוד 440,
page
441.
440-441.
Unless there is some treaty or statute to the contrary, the law of nations is to be treated as part of the law of the land. The courts of all nations judicially notice this law, and it must be ascertained and administered by the courts of appropriate jurisdiction as often as questions of right depending upon it are duly presented for their determination. Occasionally, the statutes conferring jurisdiction to hear and determine particular controversies require the courts to render their decisions in accordance with the rules of international law. When the United States declared their independence, they were bound to receive the law of nations in its modern state of purity and refinement. International law forms a part of the law of the several states. It is a part of the law of every state which is enforced by its courts without any constitutional or statutory act or incorporation by reference. And while a court may be without jurisdiction to enforce international law in a given case by reason of some controlling statute, nevertheless relevant provisions of the law of nations are legally paramount whenever international rights and duties are involved before the court having jurisdiction to enforce them. In the United States, international law has been considered as part of the law of the land not only in admiralty and prize cases, but also in cases of purely municipal character.
And in that state, where this is the attitude towards international law, there is a general decision which I will read from the Corpus Juris Secundum and analyze later. Will you please quote from the Corpus Juris Secundum, and then we shall declare a break. In the Corpus Juris Secundum, I mean, we shall conclude this morning's session. On page 236, you are reading from the Corpus Juris Secundus, yes. Volume 22, Criminal Law. The decision is, and I quote, page 236. The clause is 144.
Custody of the accused by the court or his presence therein on a proper charge is essential to the jurisdiction of the court over him. The manner in which accused is brought before the court, however, is ordinarily immaterial insofar as jurisdiction over him is concerned.
And on page 242, clause 146,
in accord with the general rule stated in paragraph 144 supra, to the effect that a court will not inquire into the manner in which accused is brought before it, the fact that accused has been illegally arrested, or that he has by trickery, force, fraud, or without legal authority, or by any illegal means, been brought within the territorial jurisdiction of a state or federal court, does not oust the jurisdiction of the court. Even if in any case there should be a conflict of jurisdiction between two courts, accused who is before one court for trial cannot take advantage of the fact that his presence has been illegally or improperly obtained.
Is this a right place to stop, with your permission? The court will adjourn, and the afternoon session will begin at 4:30, and this is not the usual hour to enable colleagues to join the funeral of the state attorney today at 4:30.
So far, so smooth.
אתה לוקח את כל הספרים פה?
לא, אני משאיר את הכל כאן.